Gary DeWaal here, and this is Bridging the Week for June 1st to 5th, and today is June 8th, 2015. Good morning. Last week, the New York State Department of Financial Services enacted a requirement that all financial intermediaries engaging in a virtual currency business first obtain a newly established BIT license unless expressly exempted. In addition, the CFTC chairman provided insight into where the commission may be headed in connection with its possible oversight of proprietary traders and algorithmic trading systems, while different firms were fined for violations of Reg Show and position limit violations. Two firms, however, disputed CFTC allegations regarding their alleged manipulative conduct. We have a lot to cover this week, so let's get started. The New York State Department of Financial Services issued final regulations requiring a so-called BIT license and establishing minimum standards for all financial intermediaries who engage in a virtual currency business activity from New York or to a New York resident. The regulations impact a wide spectrum of potential businesses, although they exclude merchants and consumers who use virtual currencies in connection with transactions for goods or services, persons chartered under the New York banking law and approved to engage in a virtual currency business activity, and persons who engage in the mere, quote, development and dissemination of software in and of itself, end of quote. This appears to exclude virtual currency miners, although the regulations are not entirely clear. In general, the new regulations require all financial intermediaries engaging in a virtual currency business to apply and obtain a so-called BIT license and to maintain certain minimum standards and programs to help ensure customer protection, cybersecurity, and anti-money laundering compliance. Under the regulations, the meaning of virtual currency is broadly construed. Application for a BIT license requires extensive information about the applicant and its principles. All virtual currency firms must apply for a license within 45 days of the unspecified effective date of the regulations or cease operating as a virtual currency firm. Nothing in the new provisions regulate virtual currencies themselves. I have a lot more details on the new license requirements in the article version of Bridging the Week, so check it out. The European Commission has agreed to postpone the date when European banks must take onerous capital hits for transacting futures or swaps business through non-European Union clearinghouses that have not been recognized as subject to equivalent oversight by the European Commission. The new effective date is December 15, 2015, as opposed to June 15th. Under the European Capital Requirements Regulation, a European bank must take a capital charge if it or its subsidiaries transact businesses through a non-qualifying clearinghouse. A clearinghouse is qualified if it is an EU-based clearinghouse and has been expressly authorized by the European Securities and Markets Authority, or is a non-EU-based clearinghouse and has been recognized as subject to equivalent regulation. Currently, the European Commission does not recognize the U.S. as having equivalent regulation over U.S.-based clearinghouses. Kraft Food Group and Mondelez Global moved in federal court in Illinois to dismiss certain charges brought against them by the Commodity Futures Trading Commission earlier this year. The CFTC had alleged that certain of the firm's wheat trades on the Chicago Board of Trade entered during 2011 for the alleged purpose of hedging were in fact placed for the purpose of artificially lowering prices in the related cash market. This activity, claimed the CFTC, was a violation of federal law and the Commission's rules. Kraft and Mondelez sought to dismiss one count of the Commission's complaint that relied on the CFTC's newly gotten anti-manipulative or deceptive device or contrivance authority under the Dodd-Frank Wall Street Reform and Consumer Protection Act. According to Kraft and Mondelez, at its core, quote, the CFTC's complaint accuses the firms of fraud and manipulation for seeking to purchase wheat at the best price it could in the face of difficult market conditions, end of quote. In a speech before the Sandler O'Neill Global Exchange and Brokerage Conference in New York last week, Timothy Massad, chairman of the Commodity Futures Trading Commission, provided some insight into regulatory initiatives the Commission is considering in response to the increased automation of trading and reliance by traders on algorithmic trading systems. Among other things, said Mr. Massad, the CFTC is considering whether proprietary traders with direct access to markets should be required to register with the CFTC if they engage in algorithmic trading. The CFTC is also considering whether it should mandate by rule certain pre-trade risk controls such as message and execution throttles, kill switches, and controls to prevent erroneous orders that have already been implemented by exchanges and many market participants themselves, offered Mr. Massad. Finally, Mr. Massad indicated that the Commission is considering whether clearing members should be required to manage the risk of their direct access customers who employ algorithmic trading. Two Merrill Lynch entities agreed to pay aggregate sanctions of approximately $11 million to the Securities and Exchange Commission to resolve administrative charges related to their alleged violation of Regulation Show, the SEC's regulation governing the short sales of securities. Under Reg Show, a broker-dealer accepting a short sale of an equity security from a customer or engaging in a short sale in its own proprietary account must first borrow the security, enter into a bona fide arrangement to borrow the security, or have reasonable grounds to believe the security can be borrowed before the delivery date. Broker-dealers comply with the so-called locate requirement by maintaining so-called easy-to-borrow lists, which set forth equity securities they reasonably believe they can borrow. The SEC charged the Merrill Lynch entities with violating Reg Show from 2008 to the present by amending their easy-to-borrow list during the course of days by effectively removing equity securities, but not stopping its electronic execution platforms from relying on the easy-to-borrow list as if not changed. Finally, two unrelated firms were each fined $25,000 and required to disgorge profits related to position limit violations involving futures traded on the New York Mercantile Exchange, part of the CME Group. Heyman Capital Management LP was charged with violating position limits on one day in June 2015 involving February 2015 crude oil futures, while Prosperity Steel, United Singapore, was also charged with violating position limits 3 trade dates involving March 2014 Henry Hub natural gas futures contracts. That must be a mistake. I doubt the violation occurred in June 2015. Both firms subsequently liquidated their overage positions, with Heyman Capital realizing profits of $709,000 and Prosperity $574,000. Both firms agreed to pay the fines and disgorge their profits to settle their CME Group disciplinary matters. Well, that's it for this week's Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWaal. Have a great week, and of course, ciao!